if you're a landlord trying to evict a tenant for non-payment of rent, and then the tenant files some kind of defense saying, "Oh well, there was a problem with the air conditioner, or there was a problem with this, a problem with that, so that's why I didn't pay the rent." That's just not going to fly here.
That's right, Tom, and that brings up an interesting point. Whether, as a tenant, can you withhold rent from a landlord when things like that break? And the answer is yes, but I see a lot of tenants go wrong here because in order to do such a thing, let's go with your example of the AC going out, the tenant actually has to deliver the landlord a written notice saying, hey, you better come and fix this within 7 days or I am holding X amount of dollars in rent from you next month. And you have to determine how many dollars of rent is that AC worth if it were working. And that is the amount you can withhold. Now, I have a lot of tenants just withhold rent without doing that notice, or they'll try to charge for some additional things like, oh, I had people come in and paid them to move my furniture so I could get to the AC unit so I could try to fix it. That stuff's not going to fly. And on the other end, the landlord also has the right to do this 7-day notice to cure in the event the tenant is in breach of something.
So that's where a lot of tenants go wrong, is they think, oh, the air conditioner's not working, I just won't pay the rent. But in fact, Florida statutes, Chapter 83, Part 2, lays out a remedy for the tenant, and that is to give the landlord a 7-day notice to, what do you call that?
Cure.
7-day notice to cure. So that notice to the landlord would say, hey, the air conditioner's not working, and if you don't fix it within 7 days, then I will withhold the rent.
Exactly, to the proportion of the value of the AC. So say rent's $2,000, really you ought to get yourself a realtor to determine what the value is. But say the realtor says $500, you could withhold $500 from the next month if it was not fixed in 7 days.
I know that that actual 7-day notice that the tenant gives the landlord, telling the landlord that, hey, you got to fix this problem or I'm not going to pay rent or I'm withhold rent, that form itself, I think the language is the tenant says I will withhold a reasonable amount of rent or something along those lines. Back in the days when I would do that for a tenant, I would tell the tenant to put right into that 7-day notice to the landlord how much rent they were going to withhold.
I think that's a requirement nowadays, Tom. The way the statute is now worded, you have to specifically tell them, and it's better to specifically tell them because then you get into a battle of, how much can you withhold and was the landlord on notice and things like that.
I would love to see the new statute on that particular issue, Caleb, to confirm that you now, as a tenant, put the amount of withholding in that notice.